Hi, I'm Avery Finnerty with the Walls Law Group here in North Carolina. And today I want to talk about one of the most difficult decisions families face when adult guardianship becomes necessary for someone you love. If you're watching this, you're probably concerned about a family member who may not be able to make safe decisions for themselves. Maybe it's a parent with dementia, an adult child with disabilities, or a loved one struggling with mental illness. You're not alone in this journey. And understanding when guardianship is appropriate can help protect both your loved one and your family. First, let's clarify what adult guardianship actually means under North Carolina law. Guardianship is a court-supervised legal relationship where a judge appoints someone to make decisions for an adult who cannot make decisions for themselves due to incapacity. Under North Carolina General Statute 35A 1101, there are different types of guardianship. A guardian of the person makes healthcare and living decisions. A guardian of the state manages financial matters. A general guardian handles both. This is serious. Guardianship may remove fundamental rights from the person, including the right to make their own medical, financial, and living decisions. That's why North Carolina courts require clear evidence of incapacity before granting guardianship. So when should you consider guardianship? North Carolina law requires that the person be unable to manage their personal care, property, or financial affairs due to mental illness, intellectual disability, physical illness, or another type of disability. Here are the key warning signs. Your loved one can no longer understand the consequences of their decisions. They're making choices that put them in danger. They're being exploited financially, or they cannot communicate their needs effectively. For example, if your parent with Alzheimer's is driving despite being unsafe, giving money away to scammers, or refusing necessary medical care, these could indicate the need for guardianship intervention. However, and this is crucial, guardianship should only be considered when less restrictive alternatives won't work. Before pursuing guardianship, North Carolina courts want to see that you've explored alternatives. These include durable powers of attorney for finances, healthcare powers of attorney, and healthcare directives. If your loved one still has capacity, these documents can give you authority to help them without removing their rights. Adult Protective Services might also help in cases of abuse or neglect. The key question is, can these alternatives adequately protect your loved one? If not, guardianship may be necessary. If guardianship is necessary, here's what happens in North Carolina. You file a petition with the clerk of court, typically in the county where your loved one lives. The court will require medical evaluations to determine incapacity, and your loved one has the right to an attorney. Family members must be notified, and there's usually a hearing where evidence is presented. The process can take time and cost, typically ranging from $2,000 to $5,000 depending on the complexity. The decision to seek guardianship is never easy, but when it's necessary, it's an act of love and protection. If you're facing this situation in North Carolina, don't navigate it alone. At the Walls Law Group, we help families through this process with compassion and expertise. We can help you understand your options, explore alternatives, and guide you through the guardianship process if needed. Visit our website at wallslawnc.com or call 919-647-9599 for a consultation.